The History and Changes of Habeas Corpus in the United States by Caitlin Atwood. During this presentation, I will discuss the definition and history of habeas corpus, the Anti-Terrorism and Effective Death Penalty Act of 1996, which changed the parameters of valid habeas corpus claims, the Detainee Treatment Act of 2005, and the Military Commissions Act of 2006. The Latin translation of habeas corpus is "you shall have the body." Habeas corpus is defined as a review conducted by courts to determine if a prisoner has been unlawfully detained. Habeas corpus was first seen in the Magna Carta signed into law by King John in 1215. The original purpose was to see that no man shall be arrested or imprisoned except by the lawful judgment of his peers and by law of the land. In the 1600s, habeas corpus was used to oppose a king's divine right to incarcerate people. In 1789, James Madison argued to include habeas corpus within the Bill of Rights for the United States. After World War II, habeas corpus was used by defendants to defend their civil rights and present illegal state actions to federal courts. An article written by Lincoln Kaplan identifies the debate of habeas corpus and points out the long-standing issues of the balance of power between national government and the states in regard to habeas corpus and prisoners' civil liberties. In 1996, the Anti-Terrorism and Effective Death Penalty Act was passed. There are 3 sections of the Anti-Terrorism and Effective Death Penalty Act with key points as follows. Title I imposes a 1-year statute of limitations on habeas petitions. Title II requires that approval must be given by the United States Court of Appeals to file multiple habeas corpus petitions. Title III identifies that relief is only available when a state court determination is found to have been contrary to or involved an unreasonable application of clearly established federal law as determined by the Supreme Court of the United States. Title I. The general 1-year statute of limitations is the main component of Title I of the Anti-Terrorism and Effective Death Penalty Act. Additionally, death penalty cases have a 6-month statute of limitations. It also enables death row inmates counsel while state habeas or unitary appellate proceedings occur. Title II. Title II expands the ability to sue foreign governments which support terrorism for the resulting injuries. Additionally, it increases assistance to those victims of terrorism, as well as compensation for the victims. Title III. Title III is meant to assist with the separation of international terrorists from financial and material support, regulating fundraising of foreign organizations who are associated with terrorist activities. Additionally, the Foreign Assistance Act is changed to isolate countries who support terrorists and strengthen counterterrorism efforts. The Detainee Treatment Act of 2005 was not just in reference to habeas corpus. The following sections were included. Section 1002 includes uniform standards for the interrogation of persons under the detention of the Department of Defense. Section 1003 prohibits cruel, inhumane, and degrading treatment or punishment of person under custody or control of the United States government. Section 1004 protects the United States government personnel engaged in authorized interrogations. Section 1005 provides procedures for status review of detainees outside of the United States. And finally, Section 1006 includes training of the Iraqi forces regarding treatment of their detainees. The Detainee Treatment Act of 2005 revises habeas corpus in that no court justice or judge has jurisdiction to hear or consider an application for a writ of habeas corpus filed by or on behalf of an alien detained by the Department of Defense at Guantanamo Bay or Cuba. The Military Commissions Act of 2006 has 10 sections, outlined as follows. Section 1 includes the construction of presidential authority to establish military commissions. Section 3, military commissions. Section 4, amendments to the Uniform Code of Military Justice. Section 5, treaty obligations not establishing grounds for certain claims. Section 6, implementation of treaty obligations. Section 7, which will be covered in more detail, is habeas corpus matters. Section 8, revision to Detainee Treatment Act of 2005 relating to the protection of certain United States government personnel. Section 9, review of judgments of military commissions. And Section 10, detention covered by review of decisions of combatant status review tribunals of property detention. The Military Commissions Act of 2006 further defined alien detainee rights in regard to habeas corpus. It states that no court, justice, or judge shall have jurisdiction to hear or consider an application for writ of habeas corpus filed by or on behalf of an alien detained by the United States who has been determined to have been properly detained as an enemy combatant or is awaiting such determination. So as a quick review, habeas corpus is the right of a prisoner to seek federal review of unlawful detention by the state. The Anti-Terrorism and Effective Death Penalty Act of 1996 revises habeas corpus to impose a one-year statute of limitation on habeas petitioners. It requires that approval must be had from the U.S. Court of Appeals for prisoners to file multiple habeas corpus petitions, and provides grounds that the state determination must have been contrary to or involved in unreasonable application of clearly established federal laws as determined by the United States Supreme Court. The Detainee Treatment Act of 2005 revised habeas corpus in that no court, justice, or judge has jurisdiction to hear or consider an application for writ of habeas corpus filed by or on behalf of an alien detainee by the Department of Defense at Guantanamo Bay and Cuba. Finally, the Military Commissions Act of 2006 provided that no court, justice, or judge shall have jurisdiction to hear or consider an application for writ of habeas corpus filed by or on behalf of an alien detainee by the United States who has been determined to have been properly detained as an enemy combatant or is awaiting such a determination. Thank you for taking the time to listen to my presentation regarding habeas corpus.